Case number 16, People versus Freddie Thompson. Morning, Mr. Don. Welcome.
May it please the Court, Alex Don of Appellate Advocates for Appellant Freddie Thompson. The plain meaning, I'd like to request 4 minutes for rebuttal.
4 minutes of rebuttal, okay.
Your Honors, the plain meaning of Penal Law 70.04 clearly provides that the initial lawful probationary sentence that is imposed on a prior violent felony conviction is the sentence that determines whether the conviction falls within the 10-year look-back period provided in Penal Law 70.04 1B4, the look-back provision.
Before we get to the merits of your claim, why is this case appealable to this Court?
It's appealable to this Court because the Appellate Division's order was adverse to Mr. Thompson, and the issue was also adverse to him in that the Appellate Division's order affirmed, as modified, the resentence. So the Appellate Division
Wasn't that in the interest of, and didn't it modify the sentence in the interest of justice?
The Appellate Division modified Mr. Thompson's sentence by reducing from 20 to 15 years in the interest of justice, but as modified, it affirmed the resentencing. What occurred at the resentencing was he was adjudicated a predicate violent felony offender on the people's motion. So the Appellate Division decision affirmed the order that was adverse to Mr. Thompson, which is what we're here to discuss today.
It has to be on an issue of law or such facts and law as would require, that led to the modification. Are you saying that this was an issue of law that led to the modification?
No, Your Honor. At the resentencing, the Court imposed a sentence of 20 years after adjudicating Mr. Thompson a predicate violent felony offender. The Appellate Division modified the numerical sentence by reducing to 15 years, but as modified, i.e., other than the year modification, it affirmed the resentencing, meaning it affirmed the order which adjudicated him a predicate violent felony offender.
Well, the question is, does it create adversity? And is your point that by sticking with the second violent felony offender, it's the second violent felony offender, right? So that created the adversity necessary.
Yeah, appellant argued in the Appellate Division I was improperly sentenced as a predicate violent felony offender, and the Appellate Division decision affirmed the lower court's order on that issue. So the ruling was clearly adverse to him, and going forward, the lower court's ruling would be binding on him in the future. Under CPL, I believe it's 415.8, where it says a ruling under this subsection binds you going forward.
The opposite side of that, I suppose, would be that every time there's a reduction of a sentence in the interest of justice, that the defendant would then lose his right to appeal any other issue in the case. If a reduction in the interest of justice from 10 to 5, whatever it is, takes place, then if the people's theory was correct, then there would be no adversity from that point on, and there'd be no appealable issues.
Correct. Correct. If I could, unless there are other questions on the procedure, I'd like to move on to the merits. It's extremely straightforward. The statute we're looking at, all we need to do to answer the question on the merits in this case is look at 70.04. The only question here, basic rule of construction, where statutory language is clear and unambiguous, courts must give effect to its plain meaning. Here the question is whether the word sentence, as used in the look-back period, includes a sentence to probation. And the statute here is clear and unambiguous. In 70.04, it explicitly states that for the purposes of this statute, for the purposes of determining whether a prior felony conviction constitutes a predicate violent felony conviction for this statute, a sentence of probation shall be deemed to be a sentence. The issue really is that simple in this case.
Let me ask you this. When there was a violation of probation here and he was resentenced to a term of imprisonment, was that sentence of a term of imprisonment imposed on the original assault conviction? Yes. Or was it imposed on the violation of probation?
It was imposed on the assault Your Honor. It was the probationary term was essentially revoked, and a sentence of incarceration was imposed.
Well, would there have been a legal basis for the incarceration but for the conviction? Where would you have a basis to impose an incarceratory period but for the conviction? Don't you have to track back to the conviction?
Correct. It all comes back to the conviction, and the conviction and the initial sentence was never vacated. So he pled guilty to a crime, and a lawful sentence of probation was initially imposed.
I had thought, though, isn't the problem with your analysis is Article, I think Penal Law 61, the legislature there, when it talked about authorized dispositions generally, I thought the legislature characterized probation as a revocable sentence.
It says that a sentence is, I'm sorry, Your Honor, that it's revocable only to the extent that it, i.e. the punitive part of it, can be altered or revoked, but for all other purposes it shall be deemed to be a final judgment of conviction. And what that basically means is that the punitive part of the sentence, the part that the defendant essentially takes away from the experience, that can be altered based on his conduct. But it explicitly states that for all other purposes, and I would submit, obviously for the purposes of determining when the conviction took place, it's a final judgment of conviction. And I think it's important to take a quick step back and look. We are here to find out what the date of the conviction was. We're starting out, if you look at the statute, it's the definition of a second violent felony offender. And a second violent felony offender is someone who's been convicted of, who has a certain conviction. And in order to define that conviction and figure out when it occurred, we need to figure out a date. And clearly, the statute contemplates that there will only be one date on which sentence was imposed.
So in other words, unless we are vacating the conviction, then the fact that we're vacating the probationary sentence doesn't do away with that. Is that your argument?
Correct. Because we're modifying the sentence itself, the probation versus incarceration, doesn't take away from the fact that a lawful sentence was imposed when the probationary sentence was imposed. And I also just want to say that everything we need to do is in the statute here. It explicitly states that a sentence of probation shall be deemed to be a sentence.
Does it make any difference what the violation is, in your view?
No.
So if he was guilty of another assault, you'd say, well, that doesn't make any difference. The fact that he, beat somebody. I mean, the whole point of violent felonies is that they're violent. I could understand if he's late for, his probation, that. But if the crime that leads to the incarceration is a serious crime in itself, is it your view that they would need to get a conviction on that in order to then count from there?
I would say it's completely beside the point regarding the question of the date on which the first conviction occurred. He may suffer consequences as a result of that new action, but in order to determine what was the date on which his prior conviction took place.
The legislature could have written the statute in the way Judge Pickett suggests, right? If the legislature felt it depends what you do, right? If it's another assault, then the date starts from that. The look back will include that particular period.
The legislature could have done a lot of things. It could have said what the people.
So true.
The legislature could have said what the people want the statute to read, which is that the answer to the question of what date sentence was imposed on a prior conviction depends on whether or not we're looking at the look-back provision or whether or not we're looking at the sequentiality provision.
So the violation of the parole, you're saying, is not the conviction that this statute is concerned with?
Correct.
That's your point?
That's the statute is concerned with identifying the date.
That's the bad act. That's the violent act that the legislature was concerned with, not the violation should you have gotten some version of leniency, shall we say, through probation.
Yes, Your Honor, correct.
Thank you, Mr. Dunn. I think we have your argument. You have your 4 minutes of rebuttal time. Let's hear from Ms. Grady. Ms. Grady, good morning.
Good morning, Your Honor.
Why isn't he correct that what the legislature is concerned about is that conviction? That's the language in the statute, regardless of what may be the basis for the violation of the parole that ends up in a resentence with an incarceratory period, that what the legislature is concerned with is that conviction.
Well, I agree with him in part. If you look at the statute, the section we're talking about is concerned with finding out whether the prior conviction is a predicate conviction. The tests then include the sequentiality provision, which does say, upon such conviction. Those words, though, were omitted from the look-back provision, and that is why my opponent's argument must fail.
Doesn't that suggest, counsel, that the legislature did not mean to include such conviction because the look-back period is focused on sentence, and there can really only be one sentence, because now we're talking about a resentence, not the sentence, and that's what the legislature says in subdivision 4, the sentence. So isn't your adversary correct that you don't need to have upon such conviction because the only thing that's important in 4 is the sentence?
Well, it doesn't actually say the sentence, to quibble, if you will. It says sentence. And I think that the answer is that, of course, there may be more than one sentence for every judgment of conviction, and the legislature knew that, as demonstrated by subdivision 3, which addresses the question of suspended sentences, tentative sentences, that they shall be deemed a sentence for purposes of the statute.
Does it make sense if you have a 10-year look-back period, and so the sentence is on this first day, and then 6 years later, because he's late for his probation appointment or something, he gets violated, that the purpose of the statute, which is to give somebody, you know, if they've reformed and over 10 years haven't done anything bad, they're not termed violent anymore. But we say, well, now he's violent because he missed his probationary appointment here 6 years after the sentence, and so that's when you start counting.
I think the answer is, what is the purpose of the look-back? You're right. It's to afford a measure of leniency. We're going to treat people who are, in fact, repeat offenders as if they were not. I think Justice Sullivan got it right in his dissent in Bell, which was adopted by this Court, that it's for the defendant to show his eligibility for release from the statute. If he has been resentenced and brought before a court with jurisdiction over him and the conviction, and the authority of the court has been impressed upon him anew, and he goes out and commits a violent felony offense the next day, yes, he should be treated as a second violent felony.
Why don't you just prosecute him for that offense? And then you've got your clock ticking. Are you not able to do that?
Well, we would. We would. That would be, that new conviction would be the...
Indeed. That's my point.
But that new conviction should be treated as a second violent felony offense that, based on the prior offense, the one that he was just resentenced for.
Wouldn't that be true because it's within 10 years of that sentence?
There's that, too. You mean the resentence? Yes.
Right.
So it doesn't.
No. The first sentence. He's got to behave for 10 years after that first sentence. If in year 6, the one I was using, he commits a violent felony, you're going to prosecute him on that, and he's going to be a double violent because it's within 10 years of the one that we've been kicking around here.
There's that, and also the sequentiality provision is satisfied as well, even though it's during the probationary period.
Right, but the point I was trying to get at was if it's not a violent violation, if it's simply failure to appear or or failing a drug test or some administrative or ministerial thing, that doesn't restart the clock on the 10 years. I think that's their argument, if I'm understanding it. And you want to say it does start the clock on the 10 years again.
It does start the clock for a future violent felony offense, looking back to that resentencing. It's that second resentencing, because remember, it's not true. I was stunned a little bit, this idea that a revocable sentence, that when it's revoked and there is a new sentence imposed, it's not the punitive part of the sentence. It's not modifying a sentence by replacing probation with an incarceration. The previous probationary sentence was tentative from the beginning. This defendant was told that at his first In 1994, he was told, this is tentative, behave or else. So it's always a tentative sentence from the beginning, and it is not just modified. It's revoked and replaced. And so now...
Doesn't Section 60.01, subdivision 4, refer to the part of the sentence that provides, if the part of the sentence that provides for probation is revoked? Doesn't that indicate that that is a part of the sentence? It's not the whole sentence.
That might, yes, that might suggest that it is. I think that the point is he's still already paid his crime victims assistance fee or the restitution or whatever aspect of it, but the probation was
part of a sentence, I don't think. I don't think those fees and restitution are considered part of a sentence.
Well, then I'm not sure what that even means then. If probation is the sentence and it's revoked, it's gone. And now the sentence adhering to the judgment is made up of the conviction and the sentence. The judgment has only one sentence now. It's the one that was imposed in 95. It's the one on the resentencing to incarceration. That's the only sentence adhering to this judgment of conviction, the 95 conviction, the assault.
Why is that, counsel? Wasn't there a judgment entered on the probationary sentence?
Yes. Yes. Upon the conviction, that phrase in the sequentiality provision would be satisfied by the 94 sentence of a probation imposed upon the conviction. But because those words, upon such conviction, are omitted from the look back when Judge Rooney was looking...
But isn't that nonsensical that the legislature would, with so obviously having one provision that is definitional, then want us to intuit that in another provision it's a completely different definition?
Well, it is a different definition. There's apples and oranges. I think what you're getting at is sentence.
My point is, you say so. My point is that that doesn't make sense for legislative construction purposes.
I think what you're getting at is what my opponent is arguing, which is that for every prior conviction there may be only one sentence.
I'm sorry. If I may just follow up. No, my point is that if the legislature has a multiple paragraph provision, and in these multiple paragraphs defines really one of the core terms, your argument is, okay, but that only provides to one of these provisions, not the others, even though the legislature never indicates that the definition is limited in the way you suggest. And I say, how does that fit within legislative construction doctrine? That we are supposed to intuit that although the definition is in this multiple paragraph provision, it only applies to the paragraphs you say, not throughout.
Because of subdivision 3. Because of subdivision 3, which demonstrates the legislature's comprehension.
Because it doesn't say upon such prior conviction?
No, sub 4 doesn't say upon such prior conviction. I understand what Your Honor's question is. Well, why should we treat...
Well, 3 is the definitional provision I'm talking about.
I don't think that that's true, that it's a definitional provision.
You
Subdivision
don't think so?
2...
Then what does it mean to shall be deemed to be a sentence? Isn't that explaining what sentence means?
Yes.
So that's definitional, right?
I thought that what the definitional paragraph Your Honor was speaking of was sub 2, sentence upon such prior conviction. Upon such prior conviction being omitted from sub 4 is my point. And Your Honor...
But once the legislature has written sentence upon such prior conviction, it is now making clear they're talking about the prior conviction in that sentence, not about the current conviction. And now the rest of these multiple provisions in the larger paragraph are about that sentence. So paragraph 2 is clarifying the sentence we're talking about.
I disagree. I think the paragraph 2 is the sequentiality provision. It is designed so that if someone goes in and commits 5 armed robberies and then is only sentenced on them on one day, he's treated as a first-time felony offender. That's the purpose of sub 2. And so that's why upon that conviction, on that date when judgment of conviction is entered, he's only a first-time felony offender. Going forward, that's the date that would establish sequentiality of any subsequent convictions. That's all sub 2 is.
Let me ask you a question about this, the revocation of the sentence. If in the 95 violation, which was a possession, but let's assume it was violent, all right, it's 95, the violation of probation.
Yes,
right?
yes. The narcotics, assuming it was a violent.
Yeah. if that revokes the sentence that was issued in 94, would he be wise to make the argument that because you revoked that one, that you can't count that as a violent felony for purposes of sentencing me on the 95 one?
Meaning, would he argue that that disrupted sequentiality, essentially? That the previous sentence doesn't count for sub 2?
All right, yeah.
The answer to that is sub 3. The legislature anticipated that, where you have people who, of course, sometimes violent offenders who get probation nevertheless go out and recommit. The legislature said, no, that first probationary sentence, although tentative and revocable, and although we're about to revoke it, that counts for sequentiality purposes. So therefore, he is a second felony offender on the new violent committed during the probationary period. That's the whole purpose, though, of sub 3, saying that the previous tentative sentence shall be deemed a sentence. It's for the sequentiality of the convictions of a reoffense during the probationary period while this tentative sentence is in place. That's the only purpose of sub 3, is my argument.
Although this issue wasn't before us in Boyer, would we be, if we agreed with you in this case, would we be saying something inconsistent with what we said in Boyer?
Only with the dictum of Boyer, what I'm calling the dictum of Boyer. I think that the problem that I had with Boyer, although I love Boyer, I just quoted, Your Honor, this court in the Second Circuit where
of course you do.
It was a double jeopardy claim. But I thought Judge Rivera's dissent made some good points. I think that well, I really did. If I could quote, Your Honor, what now? But the paragraph that Boyer provides difficulties speaks to striking a balance between what the defendant would want and what the people would want. And my argument is that the legislature already struck that balance.
Well, it also, I think, speaks to consistency rather than just balance.
Consistency, and yes, if the court agrees that there may be only one sentence for a prior judgment of conviction for 70.04 purposes, then yes, I agree it should be the first one imposed upon the judgment of conviction. But what I'm suggesting is that the purpose of the statute overall is to treat repeat offenders as the repeat offenders that they are, and that using the most recent sentence as the operative sentence for the look back gives effect to the statute and is consistent with every New York court that has considered the question.
Thank you. Thank you, Ms. Grady. I think we have your argument. Mr. Don, you have some rebuttal.
A few quick points, Your Honor. First, on the statutory interpretation and responding to my adversary's focus on the words "upon such prior conviction" in subsection 2, looking at the statute as a whole, it's clear, as Judge Rivera pointed out, subsection 1 talks about the conviction. We're defining what types of crimes apply. Subsection 2 then brings it down and says, and we also care about when this happened, sentence upon such prior conviction. And subsections 3 and 4 both continue to refer to that same date, when sentence was imposed on the prior conviction. And there is no reasonable way of looking at the statute and taking away the notion that the legislature somehow intended, by not including, by not essentially reiterating those words in 3 and 4, the notion that they somehow meant something else, that they otherwise didn't say at all. It's clear from this statute that the legislature was
assuming, counsel, that there is some ambiguity in the statute because upon such conviction was not repeated in 3 and 4. Are we to take that ambiguity to mean that the legislature expressly now wants us to treat a resentence as the date that we do the look-back period?
I wouldn't even know how to answer the question because I don't see any ambiguity. But
so there's no express language that says resentence.
There's no ambiguity, and even if there somehow were any ambiguity, there is certainly no express contrary intent expressed in the statute. And other than that, I'll just leave it at that with the statute. I think it's pretty clear. I would note on Boyer, I'd just like to say a few words about Boyer. One, much more complicated case than this one. I mean, here all we need to do is look at the statute. Boyer involved elements that arguably weren't apparent on the face of 70.04 7004. Here, it's all right there. However, and despite the dissent in Boyer, I note that both the majority and the dissent in Boyer agreed on the following. One, if the initial sentence is lawful, it controls. There was some disagreement between the majority and the dissent in Boyer as to whether or not a Sparber resentencing vacates the prior sentence or merely modifies. We don't need to get into that here. It was a lawful probationary sentence. It controls. And number two, both the majority and the dissent in Boyer appeared to agree that there's only one sentence, one date on which sentence was imposed on these prior convictions. And that's why both the majority and the dissent were looking at a rule that was supported by policy considerations that would support the identification of one date. And I'd just like to read briefly from Boyer. A rule premised on the original date of sentence for a prior conviction promotes clarity and fairness. Under this bright line rule, the defendant and the people alike can easily discern the date of sentence for a prior conviction. The people will not be able to rely on the later date of resentence to bring an otherwise ineligible decades-old conviction within a 10-year look-back period for predicate felony offender adjudication under 7004(1)(b)(4). If there are no further questions.
Thank you, Mr. Dunn.
Dicta, but it's persuasive, right?
Yes, Your Honor.
Thank you, Mr. Dunn.